Good afternoon.
Please don't make fun of me, Judge Woodall.
I would never think of doing that.
The last time I did oral argument here, I could not look down at my notes casually when I needed to and also be able to look up comfortably. So I decided I was going to find a problem, solve that problem.
You've improvised.
That's an
Yes.
excellent solution. And also, speak loudly to the mic, too, because my hearing is not outstanding, and I want to hear every word you have to say today.
Thank you, Your Honor.
All right.
May it please the court, good afternoon. Ann Short and Donald Bosch, on behalf of Sean Wagner, the appellant, I would like to reserve 4 minutes for rebuttal, if I may.
Certainly.
The operative procedural facts in this case are that in 2022, a grand jury indicted Mr. Wagner for 1 count of rape by force, 1 count of incest, and 1 count of sexual battery by an authority figure at a time when Mr. Wagner had supervisory or disciplinary power by virtue of legal, professional, or occupational status. The charges involved his stepdaughter, who was 15 and a half years old at the time, which I believe accounts for the fact that the charge of it was rape by force and not rape by coercion because of her age with that. But it involved his stepdaughter. It involved 1 episode alleged to have occurred on September 17th, 2021 at the family home, and on September, I did say 17th. Now, shortly before the trial began, the state obtained a superseding indictment. The charges were identical with 1 exception. The time frame was enlarged by 2 days to encompass September 17th through September the 19th of 2021. Otherwise, everything was identical. The day that the trial began, but before we got to jury selection, the state filed a notice of nolle prosequi as it related to count 3, citing it was for judicial efficiency and because that count was a lesser included of the count 1 rape by force. The judge then entered a judgment, as he was required to do even if a count is dismissed, dismissing that count, citing, again, judicial efficiency, and because count 3 was a lesser included count of count 1. The judgment, we believe, is important because the court speaks through its judgments and orders, and those judgments and orders are entitled to be enforced as written on appeal. Now, the proof concluded, and the judge charged on count 1, rape by force. Then, because of TCA 4018-110G4, that makes, as a matter of law, sexual battery by an authority figure and sexual battery to be considered lesser included offenses. Otherwise, they have completely different elements of rape by force, but the statute says they are. In addition, under 3915-401G, the judge instructed on child abuse as a lesser included offense, as that statute says he should do. And with the existing case law, we also obtained a lesser instruction on misdemeanor assault by offensive touching. The jury found Mr. Wagner not guilty of rape and not guilty of incest, the common element being sexual penetration. They did find him guilty of the sexual battery by an authority figure. And the first issue we have raised in our brief regards the way the court instructed the jury on sexual battery by an authority figure that we say created a constructive amendment, fatal variance. I've heard it referred to differently. I think we all know what we're talking about, but I've kind of combine the phrases. When he then instructed that the defendant at the time had custodial authority over the victim and used that to knowingly accomplish the sexual contact, which was contrary to the manner that was alleged in count 3, which had been said to be the lesser included offense in this case. Post-trial, we raised that, the jury instruction, resulting in the constructive amendment, and we raised it in the motion for new trial, and we raised it separately in a motion to dismiss and vacate that conviction. We did that because there's a little bit of uncertainty as to how the courts have viewed these constructive amendments. If it's viewed in a jury instruction context purely, and an incorrect instruction is given, then as long as that is raised in a motion for new trial, it's not waived. And so we put it in our motion for new trial to make sure it's not waived. It has also been treated in some cases as an evidency sufficiency issue, and which is not subject to Appellate Rule 3E waiver. And so we also filed an extensive briefing it that way. And then the last way we've seen it treated was in the Roger Christie case, where as a matter of plain error, the court found the conviction was void, and that was the end of it. So that's why we had the multiple ways we presented that on appeal. We cited 2 cases that we believe the court will find very persuasive. Both of them involve the appellate court reaching out on a plain error ground to find a constructive amendment in the context of charges involving sexual battery by an authority figure. Those 2 cases, Roger Christie and the Cleander Hartman case. In Mr. Christie's case, the indictment alleged parental or custodial authority. At a bench trial, the judge convicted him of use of a position of trust, and the judge also went out of his way to say that the facts do not establish supervisory or disciplinary power. And the court made very, plain error, short shrift of this. No, he has been convicted of a charge that was not made, and that was the case that said it's a void conviction, and that's the end of it. In the Hartman case, you had Hartman is important, I think, in terms of what you do if you find that, in fact, there was a fatal variance constructive amendment in terms of we're saying reverse it and dismiss it. It cannot go back for retrial. In the Hartman case, they pointed out that the original statute for sexual battery by an authority figure only included the supervisory and disciplinary aspect of that offense. It was not until later that they added the parental part of it, or custodial part of it, and they even in that case cited some of the legislative history that made it very clear that you couldn't take the disciplinary or supervision prong and use evidence showing just parental or custodial as sufficient for that. That's why we believe, if you agree with us that there has been a constructive amendment and a fatal variance, you have to dismiss, but you can't send it back for a new trial, because if a jury were properly instructed under count 3 that they had to find he had a supervisory or disciplinary power over her, as a matter of law, we know that the proof showing his position as a stepfather would not be sufficient.
Didn't the defendant agree to the jury instruction on the lesser included offense?
No, Your Honor. I think I know what you're talking about.
Or was there even an objection to it?
No. The
I
record.
mean, obviously, you're saying the instruction was wrong.
Yes, we are.
But there was no objection to that instruction as a lesser included offense of the rape count.
There was no contemporaneous objection, that is correct, Your Honor. However, because the instruction was incorrect as opposed to being an incomplete instruction, the law is, as long as that is raised in a motion for new trial, you have not waived it. And we definitely raised it in the motion for new trial, so we believe we have not waived that.
But there's not anything in the record where the defendant agreed to the instruction when it was given?
That, a different matter, and I think I know what you're talking about, Your Honor. I think the state had raised that regarding a proposed instructions that we had filed prior to trial, prior to the nolle prosequi. And we had a proposed instruction. It's at pages 124 through 27 in the technical record. The purpose of that proposed instruction, and we stated it on the face of it, was because it correctly sets out the culpable mental states for the elements of unlawful sexual contact and the victim being 13 but less than 18 years old. We were concerned, and that's what our instruction was directed toward, the mental elements, because there had been problems in cases where the judges had just looked at the statute, unlawful sexual contact, no mens rea, concluded, okay, it can be intentional, knowing, or reckless. We didn't want to have that problem. So that's why we were doing the instruction to make sure that the sexual contact could only be satisfied by an intentional mens rea in the case. Now, the fact that that's what we were doing was later supported when we went to the motion for new trial. And in that volume, and I'm going to ask you something about the numbering of the volumes in a minute, volume 14, pages 25 through 27, we raised and pointed out to the court on this very same problem, is that the court charged the defendant knowingly had unlawful sexual contact with the alleged victim in which he intentionally touched the victim. The state agreed with us. That's just a wrong statement. That muddles the intent, that's an incorrect statement, but it was relying upon the Supreme Court's decision in Clark, which that's what we were headlining with our motion, saying that it's probably harmless error. We didn't raise that in our brief because we had a much more pressing issue regarding the way the custodial and parental power was actually instructed to the jury, which was not what the grand jury found in count 3 that the trial judge said was a lesser included offense of count 1. Is that what you're referring to, Your Honor? I want
That
to
was
make
part
sure
of
I
my
answered your
question,
Yeah. Yeah. Also, in a similar fashion, let me just mention that there is a case. Neither one of us have cited it, and with court's permission, I'm going to do a one-sentence letter that I'm just going to cite this case to the court. In State versus Myers, Tennessee Supreme Court 2019, and in that case, the defendant was indicted for one offense, and at a bench trial, he was convicted of reckless endangerment, which was not a legitimate lesser included offense. Now, the state argued that he had, quote, consented to the amendment in the case. And the Supreme Court took that case and said, no, nothing in Rule 7b with how you amend an indictment was followed. And the fact that the defense attorney spoke about reckless endangerment and may have even submitted a couple of cases did not rise to the level of actively asking for a specific amendment to the indictment. So that's twofold, I guess my answer was. Did we do something that would have created this problem or that could have solved this problem. The evidence sufficiency, if you do look at how the jury was instructed, is also, we believe, a very powerful issue in this case. How did he use this custodial power? That's something separate from, was he a parental custodian? And we really did a deep dive into the appellate cases. We wanted to see if we could get a handle on what kind of facts had the appellate courts flagged that indicated use, that particular element. And, you know, in the Kenneth George Arnold case, we saw where the victim always had to ask permission of the defendant to do anything. And he turned it into a transactional relationship whereby you do something for me and I'll do something for you. He created a relationship that allowed him to use that authority. Lance Falcon, the defendant was alone with the victim a lot. She loved cheerleading. They, quote, bonded over a common love of cheerleading. He took advantage of that with her and established the kind of relationship that could constitute use. We've cited other cases, Henry Wayne Russell, and in our reply brief, the Kenneth Anderson case. But let me just get to what I think with that comes down to at the end of this. Contrast all of that with what the record does not show in this case. The evidence does not show. The stepdaughter described the relationship really as kind of distant. They weren't close. I mean, there wasn't anything particularly wrong with it, but she testified, I was always to myself because I always just kind of hung out in my room. What you're not going to find in the evidence is any evidence he was involved in any parenting decisions. He worked 60 to 80 hours a week. His wife corroborated that when she testified at trial. He never disciplined his stepdaughter. He never tried to enforce any house rules, no transactional relationship. He was never alone with his stepdaughter when the mother was not there. She did not work outside the home. He was never alone to cultivate that kind of relationship. He never tried to help her with her homework, never drove her to school, never took her shopping. No evidence she considered him an authority figure, and no evidence that she confided in him or talked to him about problems. With all of that lacking, all of those flags that we see in the other cases, then we say that the evidence is insufficient to support the verdict if you find it was appropriately charged as custodial or parental consent. And then,
I think you're getting into your rebuttal time. I just want to remind you.
oh, then fine, I'll reserve the rest for rebuttal, Your Honor. I get wound up sometimes, as I'm sure you've seen me, and you know I do, so.
Quite all right. Thank you. All right, General, good afternoon.
Good afternoon, Your Honor. Jim Gaylord on behalf of the state. So we are here on a lesser-included offense jury instruction. To get right to Judge Ayer's point, there was no contemporaneous objection interposed here. So by operation of statute, that cannot be presented as a ground for relief in motion for new trial or on appeal. Now, there's two exceptions. One is fatal variance. Fatal variance can be presented for the first time on appeal because it embraces sufficiency of the evidence. But the variance doctrine is not a useful analytical tool in this case.
Can you speak up just a little bit? I'm
Yeah.
struggling, and
Yeah.
I'm assuming if I'm struggling, Judge Wiedemeyer probably is as well.
I'm struggling more than her. She can assume that.
My apology. There we go.
Oh,
we
wow.
My
Maybe
apologies.
somewhere in between.
Yeah, that's a lot
Okay.
better.
So variance isn't a useful analytical tool in this case, because what a variance is a discrepancy between the proof and the allegations in the charging instrument. So what count one charges is rape. The jury did not convict him of rape, so there is no comparison to be done. The operative doctrine, sort of, in this case, is constructive amendment. So if a lesser included offense instruction is issued and it embraces a crime which is not, in fact, a lesser included offense, that can be presented for the first time in a motion for new trial. And that is the Myers case, which my friend has referred to, and we do think that case is important for this appeal. So the question is there a constructive amendment in this case? And all of that question asks is sexual battery by an authority figure a lesser included offense of rape? The answer to that is yes, because the statute says so. In the state's view, that is the end of this case. What the claim that the defendant has raised here is that the trial court erred in failing to instruct on a particular mode of liability for that offense. Now, whatever that is, whether it's we didn't have notice, usurpation of the role of the grand jury, it is not a constructive amendment claim, and it should have been raised with the trial judge. And this claim is also not susceptible to plain error review for three reasons. The first reason is that there's no clear and unequivocal rule of law that has been breached. What the defendant is saying here is that when the state dismissed count 3 of the amendment and noted, 3 of the indictment rather, and noted that it was a lesser included of count 1, that meant that the trial judge was no longer free to instruct on any mode of liability that was supported by the proof in the case. Well, they don't have any authority for that proposition, and I don't believe that any exists. The second reason is also something that Judge Ayers has touched on. They provided a proposed jury instruction that included this custodial authority theory.
Yeah, I looked it up. It looks like it was like just the standard instruction. It had both A and B, both parts to it.
That is
Both were
correct.
included.
That is correct. It had all 3 theories in it, but I don't think that matters. If you file a proposed jury instruction with the trial court, under the statute, the trial court is required to instruct on the appropriate lesser included offenses, except that it cannot instruct on something that isn't supported by the
Right, so my question was, the proposed instruction was, just as it kind of comes out of the forms, but the trial judge actually just charged the one piece that it found was supported by the evidence. Is that correct?
And that's perfectly okay. But what that means is that the defendant can't show that this wasn't a tactical maneuver, because generally when you affirmatively invite something from the trial court, if you say it's okay to do this, that's not plain error review. Plain error is an oversight that escapes everybody's notice that shouldn't have, because it's clear. And finally, and perhaps most importantly, there's no substantial right affected here. The right in question would be right to notice. Well, the defendant had notice. For one thing, they submitted the proposed jury instruction that included this theory of liability, so they knew that it was on the table. And the fact of the matter is, the law on this question is that once you're indicted for an offense, in this case rape, that includes all lesser includeds that are supported by the evidence. And the trial court has the authority to charge any of them. And they knew that, and are deemed to have known that. So there simply is no notice issue in this case, even if we were somehow under plenary review. And at the end of the day, what the defendant here is saying is that the trial court was obliged to instruct on a theory of liability that is not supported by the facts. They're saying you had to instruct on supervisory disciplinary authority, which does not apply to step parents. This court has said that in the Hartman case, because of something that the state said in connection with dismissing a separate count of the indictment, which is in fact a separate case. We would ask the court not to go down that road. Okay, on sufficiency of the evidence, if if there are no further questions on the constructive amendment question. There's ample evidence supporting the use of custodial authority to accomplish sexual contact here. Defendant is the victim's stepfather, and most importantly of all, he pays for the home in which they both reside. The home is the source of his custodial authority. That's what makes him a custodian, is that they cohabit together and he owns
pays all the
homes.
expenses, doesn't he? I mean, did I
Yes.
understand correctly that the mom did not work
Yes,
outside the home?
his own testimony in the case is that she's a homemaker and he works security for Y2K. So in addition to insurance and cell phones and the house, it appears that he paid for everything. But what, excuse me, but once he accomplishes his assault in that home that he owns, which is the source of his custodial authority, that's sufficient evidence all by itself. And I don't believe that there's any contrary authority. But there's more. The victim essentially played dead when all of this was going on. And I think the jury could reasonably infer that she would not have done that she would have resisted earlier had he not been in a position of authority over her. And finally, she didn't go to the authorities. And she didn't go to the authorities because she was afraid of losing her home. She said, I didn't want to mess things up. And the jury can also reasonably infer from that he was hoping, by virtue of his custodial authority, that he might get away with it, that she might not go to the authorities at all. So we would submit that the evidence of this offense is more than sufficient. If there are no further questions, we will ask that the judgment be affirmed.
All right, thank you, General Gaylord.
Regarding the constructive amendment, and I've heard now several times, there was no evidence to support instructing on supervisory authority in the case, and that's what the court was supposed to look to. Well, let me query this, Batman. How did the grand jury return an indictment count 3, presumably based upon a condensed version of the proof that was presented at trial? The grand jury voted that he was in a supervisory or disciplinary power situation with her, not the step-parent or custodial. So I'm not sure how that cuts, because with this kind of proof, even condensed, the grand jury said, okay, it fits this mode. Then we go to trial. We have the state saying, yeah, that mode specifically is a lesser included offense of count 1. And we have the judgment that says the same thing. The sufficiency, the courts have looked really to the nature of the relationship. He says, well, they're in the home. He pays for everything. That's a good basis to establish that, in fact, he was in a custodial or parental relationship. Does simply being in the home and doing that establish he used that authority? We say no. And we say you've got to. When we looked at the case law, they were always finding something else. And in our reply brief, it was interesting. It was a biology teacher who was arguing he could not have used his authority derived as a teacher because the sexual contact occurred, I believe it was at his home, outside of the source of his authority in the case. And the court said, no. Yes, the school may be the source of his authority, but how he used it was by cultivating this relationship with this young lady, being alone with her a lot, taking her to his home, letting her spend the night. The improper cultivation of the relationship was what allowed him to use his authority. And, Your Honor, we absolutely dispute the somehow, she didn't say anything because of his custodial use and didn't report it to anybody. I mean, the evidence really, absolutely shows in this case. When this happens, when she testified to it, her mother is about 7 or 8 feet away in the bedroom, asleep. And when this was over, according to her testimony, she jumped up, went into her room, and the first thing she did was text her mom, "Hey, Mom, come in here, come in here." She immediately reported it to her mother, who then went out and confronted Mr. Wagner. So respectfully, the facts absolutely will not support that particular argument as to the sufficiency in this case. I don't know if there are any questions regarding if either of these two issues prevail, where does that leave us in the line of lesser includeds? I think we've tried to brief that pretty extensively, and we believe the only lesser possibly that could support a conviction might be that misdemeanor offensive touching in this case. Thank you, Your Honors.
All right, thank you.
May I ask now, nothing to do with this case, but just a point of clarification. It's taken me a long time, but I'm finally comfortable going in and looking at the record as it's scanned in by the clerk's office and as they send it to me. And when I open that up, you know, it'll pop and it'll say, transcript of evidence PDF 1. Of course, when you open it and you look, as I in the old days would, to the cover, it has a different number up there. I don't know if the court is mostly going by the electronic record or by the old record, but what we did in our brief was if you pull up the electronic record and you see a reference to transcript of evidence, it's how it appears in that listing, not how it may appear on the first page when you open it up, if that helps. And I'm not sure if the court has a preference or would want it done both ways or whatever in the future. I just throw that out there.
On advice of counsel, I refuse to answer your question.
You want to answer that?
I mean,
Our hard records are the same as the electronic
Yeah.
records, so.
I mean, saying this is a transcript, I'm looking at that red or black number that they write up there, 1, 2, 3, that's what I'm looking at. So if you're to give me a site that says volume 2, I'm looking for the transcript or whatever it is that is written on it, volume 2.
Okay, to get to that, to look at that volume 2, Your Honor, are you clicking on?
So our system's gonna be our accessing system's a little different than the public accessing system. So
But what's in the computer is the
It's still the same,
as
right. I mean-
the hard record, so I'm
ours
confused.
just is gonna say transcript